Look now, if you would, at the 1-to-4 family contract. I believe you have a copy of it in your package. And we're going to go through paragraphs 1 through 5 and talk a little bit about those paragraphs. Again, as we have been doing at any point in time that you have a question, if you think of it while we're actually on the paragraph that you have a question about, stop us. If you think about that later, we'll go back to it. So don't. It's okay if you're not quite with us yet because the coffee hasn't kicked in. Paragraph 1 obviously is parties to the contract. I don't get a lot of questions about paragraph 1, and I think maybe we have kind of got that one nailed. You've put down the name of the seller and the name of the buyer. Is that not true? Either do you see a lot of problems with paragraph 1?
No.
And she said no. Okay. Paragraph 2, of course, describes the property that is being conveyed, and we all know, I think, that we would be putting in the legal description in this paragraph as well as the actual address of the property. And we also should know that if we have a property whose description is more complicated than lot and block and subdivision, that you have a provision here to attach an exhibit that would have the legal description, which might be more complicated. But I noticed when I looked around the room earlier that we have some title company people in the room, and I think they would say to you that if we don't really tell them which property that the people are buying or the people are selling, it gets a little complicated for them to finalize the paperwork. So they appreciate accuracy in legal description. Is that correct? Okay. Okay. And for the record, the title companies all said yes. And there was a question in the back.
Great question, actually. When it comes to people who are married, currently married, because Texas is a community property state, unless there is some sort of a written agreement between the husband and wife saying that the wife is going to be purchasing this property on her own as separate property, then both parties need to be on there, and the property is going to be purchased by both parties. If you do have one spouse that wants to purchase it on her own, I recommend you advise your client to go and speak with their attorney to have such a document drawn up where the husband and wife are agreeing that this property is being purchased as the separate property of the wife, separate funds, and actually attach that to the contract. You do want to have that to be very clear, because if it's not specified, it's going to go into the community.
We get questions from time to time about people who owned a property prior to a marriage, or there's been a divorce and there's a property being sold, and who has to sign what. And I think I know the lawyer answer, but I also think I know the title company answer. So.
Okay, all right. So those may be different. So I'll address it from the lawyer perspective, and we'll let Avis give the practical one. If there is a parcel of property that has been given to one of the spouses in a divorce decree, then it's okay to go ahead and have that individual to sign all of the documentation. But I would go a step further and attach that divorce decree as well to the contract, so that it's very clear who the actual owner of the property is, and you have documentation saying, this used to be part of the community, it was given to me in the divorce decree, it's now my own property.
Is there any special language that has to be in the divorce decree for that to occur? The answer is yes.
Yes.
That the divorce decree actually has to specify the property by legal description, an actual address, and divest all interest, title, and right to in the divorce to the other party, or convey with a special warranty deed that property at the time of the divorce. And I see title people shaking their head in an affirmative way. If you have a currently married couple and they own a property in community, and one of those parties, in this example, the wife was on an extended vacation, and tonight you need to sign a contract. John, you're saying, does his signature bind her?
Exactly. Well, and again, because this is a community property state, one of the spouses does have the power to bind the community. That's kind of the legal, theoretical answer. Now, I would always caution against doing something like that. You do want to make sure that you do have both parties on the contract, so that you don't run into problems at the title company or something like that, or have a situation where the buyer says, oh, well, this isn't an ineffective contract because both parties are not on it.
Paragraph B includes all of those things that are attached to the property. Nailed down, screwed down, glued to the wall, glued to the floor, whatever, attached to the property. And that gets a little complicated sometimes about what's attached and what's not. And then, of course, you've got paragraph C, which includes things that may not be nailed down, but are considered personal items that are going to convey. And you see all those things. If any one of those things or anything else that you think might be in question as a listing agent is not going to stay, or your seller instructs you that they intend to take any of these things, you would want to put those things in paragraph D. I point this out to you specifically because some of you use the Austin Board of Realtors seller disclosure document with your seller. And in that document, there's a place for the seller to say the things that they don't intend to leave in the property. That's a disclosure, not an agreement. So that whatever is written in that seller disclosure that is not going to convey needs to make its way to paragraph 2D, or someone is going to buy that thing, whatever that thing might be. Because the seller disclosure is a disclosure. This is an agreement.